Glenn Kirschner, I want you to take me through substance and tone of what the government argues, because it feels like they've laid a bit of a trap for Judge Aileen Cannon. If she goes against the government, they have already described those sort of judgments as frivolous and nowhere in the law.
So first of all, Nicole, let me start with the tone, because that may be what I enjoyed most. I mean, it makes clear that Jack Smith and his team do not mince words. They do not pull punches, and they recognize that done right, justice is a full contact sport. And they went 100 miles an hour after each and every assertion that Trump's team had made when they filed their request a few days earlier that Judge Cannon set no trial date. And, you know, the first thing that Jack Smith and his team pointed out on page 1 is that that actually violates the law, the Speedy Trial Act, which says a defendant once charged, you know, the judge then has the responsibility to set a date certain for the trial to begin. And somehow that escaped Team Trump when they filed their, you know, PR piece with Judge Cannon, mentioning over and over again, you know, I don't know if you realize this, Judge, but, you know, Donald Trump is running for president, and that takes up a whole lot of time and energy, and he doesn't think he's going to be able to fit in a federal criminal trial. I mean, I would urge everybody to read both of these two pleadings. They're 10 pages each. They're double spaced. And Jack Smith's reply is really compelling, and I think it's foreshadowing of how we can expect Jack Smith's team to perform once this case is in trial.
I love when you give us homework, Glenn Kirschner. It is a really important point, though, because we're all trying to read these tea leaves. And the most we know about Jack Smith, we actually know from his filings. And I'm glad you started with tone. I wasn't sure myself if it was frivolous to focus on it. But I want to ask you if it's going too far to say he's basically throwing shade when he writes about, you know, lots of criminal defendants have busier jobs than you that require lots and lots and lots of travel. Basically, you're popping around on your own plane in and out of state fairs. I mean, it feels like it almost borders on just a little bit of shade.
A little bit of shade, and he really is throwing down the gauntlet for Judge Cannon. He is saying, first of all, the law requires that you set a date certain for the trial. And Jack Smith has now twice gone on record in his filings as saying, and December 11th, 2023 is the trial date that we are requesting repeatedly. That gives the defense team plenty of time to get ready. And, you know, the people are entitled to a fair trial as well, not just the defendant. And, you know, that as compared to Trump's request that she set no trial date. But you know what, Judge, if you have to set a trial date, go ahead and push it out well after the November 2024 presidential election is going to be the first real test for whether Judge Aileen Cannon has learned her lesson from the criticism of the 11th Circuit Court of Appeals and, you know, does the right thing and sets a timely trial, or if she continues to cater to Donald Trump the way she did previously. And, you know, I think everybody is going to be watching that next week to see whether she can redeem herself.
Watching and maybe not holding our breath. Frank Figliuzzi, let me bring you in on, again, my non-legal analysis is basically calling phooey on Donald Trump's defense, which is a noun and a verb in the Presidential Records Act. This is what the government, the Smith team files. Quote, the Presidential Records Act is not a criminal statute and in no way purports to address the retention of national security information. The defendants are, of course, free to make whatever arguments they like for dismissal of the indictment, and the government will respond promptly. But they should not be permitted to gesture at a baseless legal argument, call it novel, and then claim that the court will require an indefinite continuance in order to resolve it. Basically, using Bill Barr's favorite word and calling BS on the notion that there's any defense other than perhaps political or rhetorical in the Presidential Record Act for the crimes Trump is accused of committing.
You know, we're getting more than a glimpse here into what this trial is going to be like, even in pretrial motions and filings. And I love that part of this because, you know, we're seeing this play out back and forth in the paper and it's very insightful. Look, the Presidential Records Act is indeed about a president declaring documents to be personal and his. There's not even a dream of it applying to classified information and documents that have been demanded repeatedly by the government. So that's going to go nowhere. And yes, it's an act of desperation by the Trump legal team to continue to, even this early, push that notion that, we've got this new idea, it's going to take forever. But I want to, Glenn really adeptly handled the legal issues inherent in this claim of, hey, let's extend this thing beyond the election. Let me handle the national security concern, which is the longer this gets delayed, the longer the public is denied the information we need to know to make a more informed decision about an election, the more dangerous this becomes. And Trump is a continuing, clear and present danger to national security. If the judge decides this can go on indefinitely, she's essentially saying we can live under this threat indefinitely. And that needs to stop. And, if she's going to weigh the issues, and yes, there are some interesting discussions here to be had about, hey, should we be prosecuting an active candidate for president? He is a private citizen. And so any interest in allowing somebody unfettered to run for president without being touched by criminal acts and prosecutions is grossly outweighed by the public interest in vetting and knowing and preventing a threat from taking office again. It's a no-brainer, but we'll see if Judge Cannon can grasp it.
Mike, I know you're a student of how the federal government has very uncomfortably at times dealt with the tsunami of disinformation and lies that comes from Trump and his lawyers every time they're under scrutiny. And I want to read you something that was, subtle's the wrong word, but sort of tucked into this filing. This is from your colleagues reporting on the government's filing yesterday. Mr. Trump's lawyers also complained that a first trove of discovery evidence provided by the government was expansive, including more than 800,000 pages of material, and would take a significant amount of time to sort through. Prosecutors shot back, the Times reports, saying about a third of those pages contained unimportant email header and footer information, and that a set of key documents that would guide the defense toward the crucial sections of discovery was only about 4,500 pages. It's sort of a fact check wrapped in a calling out the spin wrapped in a filing.
Yeah. And, to the point that you were making in your introduction to this will really probably be the first real test of Judge Cannon. There were these, what legal folks in the circuit court said were unusual decisions that were made in the search warrant. The government has ended up in front of Judge Cannon here, probably in a situation that was possibly a nightmare to them. And as we've outlined in our own reporting, she's someone that has very little trial experience. She's overseen less than a half dozen trials. None of those trials lasted more than 5 days. And there could be no trial more complicated probably than this one, maybe in American history, because it doesn't just involve regular sort of run-of-the-mill criminal charges. It involves classified information and a whole separate set of rules and sort of guidelines that are used in how those materials are handled at a trial where information is supposed to be aired publicly, where the public is supposed to be able to come in and see those trials. So what this will be, and it'll be fascinating to see, is what does this say about how she is going to oversee this trial? Like, Trump is asking for something that appears to be extraordinary, and we'll see what the date on this really looks like. The thing that I wonder about and that I think about is that we know that there are still ongoing strands of this investigation that the prosecutors are looking at, and are they looking at stuff in New Jersey? We know that some of this stuff relates to stuff in New Jersey. And if Cannon were to become a real problem for them, how could they pivot out of that? And are there other options for them?